How do you advise clients on whether to litigate a DUI case or take a plea deal? Attorney George C. Creal explains, every case is different, so the decision to take a plea deal or litigate will depend on the facts and circumstances unique to a particular case. The best strategy is to carefully review the evidence, talk to witnesses, and examine the underlying data from the chemical test prior to making a decision. Oftentimes, we will hold a motion hearing to determine whether or not evidence can be restricted or suppressed for the trial of the case, as well as to get a dry run on the evidence that will be presented at trial to a jury. This provides us with an idea of what a jury trial would look like in terms of evidence and potential for reasonable doubt, which will allow us to intelligently weigh the pros and cons of trial with our clients. The standard of proof in a criminal case is proof of guilt beyond a reasonable doubt, which means we do not need to prove innocence. We must only show that the prosecution lacks sufficient evidence to prove guilt beyond a reasonable doubt. Reasonable doubt is the difference between thinking someone is DUI and knowing they are DUI. If the juror thinks our client is DUI but does not know it, then the law requires a non-guilty verdict. If we can show that there is a reasonable doubt as to whether or not the defendant indeed committed the crime of DUI, then we should win the case. Take the safe road by hiring attorney George Creal and his team, who bring over 50 years of courtroom experience to counsel's table, providing your case with the individualized time and attention to detail required for success.